afternoon, everybody. Thank you for joining us on our latest webinar. And just for those who don't know me, my name is Mike Hall from ThinkSMART Marketing, and I own the business along with Claire Taylor and Gary King, and we're all about helping people with their marketing strategy, making sure they're getting a maximum return on investment. And we love to add value to people, which is why we're running a series of webinars. And I'm delighted to introduce Jemma from Clarion Solicitors.
Hi, everyone.
So
Hi.
we're going to talk around brand and IP and all those kind of intellectual things that Jemma knows absolutely loads and loads about, probably more than we can fill in half an hour.
Yeah.
So if you'd just like to introduce yourself,
Yep.
And then we'll kind of take it from there.
Yeah. So I'm a senior associate in the intellectual property team at Clarion. I trained at Clarion for 2 years. I've been there around 8 years now. All our matters deal in all the IP rights, so patent, trademarks, copyright, designs. We deal with matters to do with confidential information, domain names, so kind of the whole range of IP rights. We do contentious work, so essentially dealing with infringement. So if our client needs to enforce their rights against a third-party infringer, we help with that. Similarly, if our clients are accused of infringement, we help them with that. Also, a wide range of non-contentious work. So in terms of putting together agreements, maybe for clients to be able to exploit their IP, maybe license it for a royalty or sell it to somebody. We also help out our corporate team who do corporate transactions, so buying and selling businesses. So wide range of work, really. As a firm, we have a variety of clients. So I work with small startup businesses right through to large PLC clients. So we do a wide range of work within intellectual property. The only thing we don't do, which is usual for lawyers, is draft patents, because that's kind of a very technical document that requires kind of a patent attorney to have the relevant knowledge in that field and the degree. So yeah, that's in short what I do.
It's quite a bit to go at there, isn't it, really?
Was that the short version, Gemma?
Sorry, yeah. It's probably
Clarion a lot like to talk. I don't know if you've noticed, Mike.
Yeah, I've gathered that one. So what we'll do is we're going to have a chat around things. If you've got any questions, then please pop them in the chat. We'll do some questions at the end. But if you come across something that's really relevant, you want to drop it in, and then we'll take it from there. So Jemma, just kind of looking at it from my kind of layman's perspective, a lot of people know I like to look at stuff really kind of simply from that perspective. What, as business owners, the first thing that jumps into my mind is thinking about how you can protect your brand. What do you need to do around, whether it's just your logo, that kind of thing.
Yeah.
Is that a fair consensus that, it's one area that people kind of struggle with or wonder what to do next?
Yeah, it's an area that people, I don't know if they struggle with it, but actually it's the area that kind of is the first point that people think of when they think of IP in businesses. So it's a popular area, and actually it's an area that all businesses have a brand. So actually it is a very important area. And I suppose from an IP point of view, there's kind of two aspects to it in my view. So the first is look at it kind of on a negative, is the risk. So if you set up a new business under a new brand, or even if you start provide a new service or product under a new brand, the first thing to consider is actually, from me using this brand, is there an issue that I'm going to start infringing somebody else's IP rights? So does someone already, say, have a trademark, or does somebody already have rights in a conflicting brand that because they've used it for so many years, that they have goodwill in that brand? So it's first looking at that and looking at, is there a risk here? And there is a few ways of doing this, and what we usually advise is to do quite a comprehensive kind of, we call it a clearance search, which looks on the register at the UK Intellectual Property Office and the EU Intellectual Property Office, and does kind of this. We use a third-party company that has quite a sophisticated database to be able to do these searches. And so that's one way of doing it. You can kind of obviously Google things and look on the UK Intellectual Property Office website to see if there are any kind of identical marks. But the reason really it's good to do kind of a proper job, if you like, and get these comprehensive searches is that it's not just if someone's using, say, an identical word or an identical logo. It's actually if something's kind of confusingly similar. And even if they're using it on confusingly similar services or goods. So it's not always as straightforward as, oh, well, no one else is actually using it or has rights in this exact brand. And I think that's probably where businesses maybe slip up a little bit, because they don't see that the similarity point is actually really relevant. So that's kind of the risk side of it from brand protection. And then we get on to, well, should I be getting a trademark? And it's an important right to have, because actually if a company comes along and is using a conflicting mark, so maybe the obvious examples are logos and your name, essentially. The easiest way of being able to stop somebody is having trademark protection, so a registration in the relevant country. There is such a thing as a passing off action. So if you've been using the mark and you have goodwill in the mark, all is not lost just because you don't have a trademark. But actually trademarks are much easier to enforce because they're a registered right. So they're the two, I always see there's two sides. So the first being risk and the second being protection. And as part of that, I suppose what you need to be looking at is prioritizing which countries. So you can't just get a trademark for everywhere in the world. You need to look at it and direct, I suppose, the resources to the relevant and most important countries.
So is this about then kind of taking a little bit of a step back? So if you're developing a new brand, product, service, whatever that might be, it's kind of understanding to some extent the target market you're going to work with, where you're going to position this thing or whatever that might be. And then do you kind of push, so if you were to work with an agency, for example, to help you develop a new brand, does that fall on them to then go away and do the research, or do you have to do it as a business yourself? Because I could see that being a kind of a funny area where you go and, I mean, we've had experience where you go and look for things, come up with a great name for a company, you go and find the website and find it's gone or it's not there. So you've got to change things around a little bit. So understanding where you kind of start on those kind of things.
So it depends, I suppose, what approach you want to take. I mean, I've worked with marketing agencies, and when kind of developing the brands, they might run a few of the names past me. That so say they've got 5 names that are an option and they haven't plumped for one yet. But actually maybe to run them past us to maybe narrow them down and understand the level of risk involved. But actually, ultimately, I suppose it's up to the business to make sure that they're doing the right checks. And also, ultimately, it depends on the agreement that you've got with your marketing agency and the terms and conditions as to who's ultimately going to, I suppose, be liable if there's an infringement risk. And you would generally expect it, I suppose, to fall to the business. But it depends what you've agreed with your marketing agency in reality.
So it's taking this joint approach, isn't it, like a belt and braces, effectively, to kind of make sure that you are covering all those things. Because there's nothing worse than going, look at this brilliant design, and the client goes, I love it. And then you go, oh, heck, we can't do it. So it's about getting those kind of priorities in. And the other thing that kind of we touched on yesterday when we were talking is this stuff doesn't happen overnight either.
No.
It can take a little bit of time, so it needs kind of planning in if you're gonna start looking at things.
Yeah, and especially with the kind of the clearance searches, it needs to be done at the right time, because actually if you've got your brand, you've spent money on, say, for example, packaging or some sort of marketing materials, then you do the clearance search and you find there's something that's very high risk and you're not happy with it, you're then in a bit of a difficult position in the fact that you've already spent money on the brand as to whether you just kind of go for it and take the risk. So if you'd have done the search before you actually put some money into it by printing doing the design or anything, and your marketing material, you're in a better position then not to feel under pressure to kind of go with a brand that you might otherwise have thought, well, actually this is a bit risky.
So there tends to be there needs to be a bit of forethought, isn't there, into what it is you're doing, and that's
definitely.
And is that kind of, you touched on being able to search on Google or those kind of things? I guess what we're saying is where, if you didn't want to necessarily engage with a lawyer straight away or someone like yourself, is there places you can go and look for this kind of information? Is it kind of free domain, or do you need to then
Yeah, so if you, I suppose in the first instance, obviously Google is a good starting place just to see what is already out there. And if you found that somebody was using the exact same name on the exact same services, then you might be thinking, oh, well, this could be an issue. And obviously then you've saved time going to a lawyer to check whether it's an issue. And actually the UK Intellectual Property Office is a public register, and so there are search facilities on there. So as a first port of call to kind of knock anything out of the water, you could have a look kind of as a business yourself. But then obviously we would never say that they're good enough searches for you to have a kind of confidence that you're not risk-free. It's never risk-free, but to have a level of confidence in understanding, I suppose, the risk is to do the more comprehensive searches. But yeah, by all means, there's most of the kind of registers for trademarks, so the UK Intellectual Property Office and the EU Intellectual Property Office have these search facilities.
I mean, I know when you and I first we met through Connect Yorkshire, and we were chatting about various things, and we were talking to you about a touchpoint program and whether you can, put an IP around all that kind of thing. So we talk a little around sort of the things that you can and can't do. If there's an element of, everyone thinks I've got an idea, I can do it. Can I slap an IP over it and stop anyone else ever creating a touchpoint program? Probably not. But it's knowing, I guess, what's possible and what isn't possible.
Yeah. Okay. So I suppose from an IP point of view, you've got to look at two aspects. So one, what registrations you can get, and two, what automatic protection you can get. So from a registration point of view, we've already spoke about trademarks to protect the brand. But if you've got a product and say you want to protect the look of it, so the appearance of a product, then a great right that people don't always think about is registered designs, and that's a really useful tool. So that essentially just protects what something looks like, and there's a lot of freedom as to what you can protect. So you can protect the whole of the product, or if there's a particular part that's very important, you can protect that specific part of it. So there's a lot of freedom. So registered designs are really, really useful. And then obviously you've got patent protection, which is for anything that's particularly inventive. So an inventive way of doing something, or if the product itself is inventive. So there are kind of the more obvious registrations for protecting things. But Mike, I think what you were kind of getting at there is not everything is protectable by way of a registration. But copyright in this country, at least, is an automatic right, and it generally is an automatic right. So you don't have to file for a registration. You can do in certain countries such as China. But saying in the UK, let's concentrate on the UK, it's an automatic right. So if you, for example, create some marketing materials that have graphics and text, copyright will automatically subsist in those as long as it's original. So the thing you can do, I suppose, to kind of bolster your protection and make sure people on notice is put kind of copyright notices and things on websites and all that sort of thing. But in terms of copyright, it's an automatic right. Where you can't get protection for something, so one good example in the UK is software. Certain software is protectable by way of a patent. So that's the best protection really you can get for software. But actually, it's really quite difficult because it has to have some sort of technical effect. And often software doesn't have this technical effect. In terms of the software, there's obviously the interface and the source code itself. So both of those elements, copyright will subsist in those as well. So sometimes to try and protect as a deterrent, I suppose. And if somebody was to try and take the source code, sometimes what people do is maybe put a bit of redundant code in the source code itself, because if someone takes that source code then, and there's this redundant code that there was no reason for it to be in there, it's pretty difficult to kind of justify that and say that you haven't copied it. So that's the software element of it. But also one key thing that people probably don't think about enough, and it's absolutely key, is that if you can't get a patent for something in particular, but there's some sort of know-how within the business, to keep it confidential and to make sure the agreement's in place to make sure that the people who have to have access to that confidential information are under duty, so contractual duties not to disclose it to somebody else. So that's kind of absolutely key with certain things. And so I suppose Coca-Cola is quite a good example of how kind of the recipe is protected, and there's various stories about how they do that. But yeah, so that's kind of just a summary of all the different rights, I suppose, as to what you should be kind of thinking about if you develop a new product or provide a new service, as to kind of the key things to think about.
Yeah, I mean, I've just had a couple of questions. I'll come on to the questions that Rob's put in a minute. I mean, one of the things that we kind of have, the reason we wanted to chat with you about is being mindful of, if we're talking to clients and we're working on their marketing plan to go through and what they need to do, is that if they're saying, actually, we want to go to this new process, or we want to develop a new product or a new liquor, or whatever that might be, it's making them aware that actually this needs to be considered, because we don't want to get the end of a project and they fail because it's not been checked out. So it's almost building that in, build that into part of the plan. So actually there's an expectation to say, actually, you need to do this bit, guys, because it's really, really important. So
yeah, I agree.
To kind of filter that in.
Yeah, and I think it's having people in the business be aware of when they need to identify that IP is being created. So it's the design teams, it's people that are coming up with the innovative products. Are they in a position, do they have the knowledge to then be able to identify that something's been created, and then speak with whoever they need to speak to about whether they need to put some sort of protection in place. So it's having, like you said, building it into the plan, so that there's a not a policy, but there's a plan within the business as to how and who is responsible for identifying what's being created. Because otherwise you could, so for example, on a registered design, say you come up with a product that you like the look of it, you want to protect it because actually it's pretty unique. Say you don't get round to doing that for over a year, then you lose the opportunity to get a valid registration, because you have to say this 12-month grace period that then will have passed. So I think it's having a process and a plan in place to identify it.
Sure. Just got some great questions coming in, which is good.
Okay.
So, question from Rob, who's in Reaction Marketing. Can you put copyright on an original brand name you create, even without registering it? So,
copyright usually subsists in what we call they call it broad terms of work. So, it's usually kind of a literary or an artistic work. So, let's take a logo, for example. And a logo copyright will automatically subsist in that logo if it's original. So you would want to get trademark protection for the logo, and if you don't have trademark protection for the logo, if somebody copied that logo, you could potentially rely on passing off if you've been using it, or you could potentially enforce your copyright in that logo against the third party that kind of has copied it.
Okay, hopefully that answers your question, Rob.
To some degree, thanks, Jemma. I guess what I was just trying to get at is not just the logo, but maybe your company name or a product name. If you just put TM or C next to it, is that okay to do that? It's just to try and ward off other people trying to use it, even if you've not formally registered it?
Yeah, it wouldn't be standard to put the C next to a name, because it's probably less likely that copyright will subsist in a name, because it won't have kind of the original quality to it, in the fact of like a copyright work as in a literary work or something like that. I don't think a name generally copyright wouldn't generally kind of subsist in quite a short name. But you make a good point on the TM. So a lot of people don't realise that the TM is for an unregistered. I mean, you can use the TM for registered and unregistered trademarks, but the R in the circle should only ever be used for a trademark that is registered and in the form of that registration. So the exact form that you have registered. So that's only really when you can use the R, because if you use the R when it's not registered, it's technically a criminal offence. But the TM is a great thing to use next to a name, because even if you don't have a trademark, it's showing to the world essentially that you're treating that as a brand, and you're treating that as a brand that you identify with. So the TM next to a name is more usual than putting the copyright symbol.
That's great. Yeah. Thank you. Just
thanks for the question, Rob. Great question. Ellen's come with a question. What sort of costs are associated with TM?
So trademarks, compared to, I suppose, some people are put off because, say, patents. I mean, patents are a lot more expensive. Designs and trademarks are pretty cost efficient really for the protection that you get. And with a trademark, if you continue to renew it every 10 years, it never ends, as long as you just keep using it and as long as it remains valid, so people don't try and attack it for various reasons. So you could probably get, I mean, the UK Intellectual Property Office has fees that are based on how many classes you would cover. So just so you know, when you file a trademark, you need to pick the goods and services that you want the trademark to protect, and that will fall under various classes. And so it depends how many classes you want to apply for, but essentially it can cost you hundreds of pounds rather than thousands of pounds, is probably the best way of putting it. But it depends, I suppose it depends if you want a lawyer's input into making sure the specification is kind of gives you the protection that you would want. And it also determined by how many classes you cover, but it generally is quite a cost efficient IP right to obtain compared to, say, a patent that is more expensive.
And just adding on to that, is that something that can happen fairly quickly again, or is that something that can take time depending on how many classes you're looking for? Does that vary? It's just something to be mindful of when you're looking to, I guess, start that process of getting it done.
Yeah, so usually if we just say, take for example the UK, we would file the application and then the process is then it's examined by the UK IPO. Depending on, I suppose, their workload, it depends on how long it takes to examine the trademark, but it should only be a few weeks. And so then it's published. And then there's a certain amount of time. So there's 2 months within which then somebody can file a notice to oppose that trademark. Say, for example, if they think they've got a prior right, so they can file a notice, which then extends the opposition period, as we call it, to 3 months. And so you will always have that 2 or 3 month period from the publication. And then once that's passed, as long as no one opposes it, and then it should proceed through to registration once it's processed. So we generally say if there were no issues, you're probably looking around 4 to 6 months to get a trademark through to registration.
Right.
But if once you've filed it, even if it takes a while to go through to registration, once you've got that registration, the trademark protection then dates back to the filing date. So it's not kind of you've lost that protection. Once it's actually registered, the protection that you get goes back to the filing date.
Right, so it's all retrospectively added and things like that. Okay, brilliant. Dominic's got a question following up from that. He's got registered trademarks up for renewal. Why keep them and just rely on copyright? Do you want to elaborate on that one, Dominic?
Well, I've got a number of trademarks, and I'm just wondering. I mean, nobody's ever threatened them. They've been around for quite a long time, and the obvious question is, do I keep spending money keeping them as registered trademarks or just rely on them being trademarks?
So I would, if you are using them and they are a valuable asset to the business, I would continue to renew them. And the reason for that is, well, there's a few reasons actually. So in terms of a brand, whether it be a name or a logo, a registered trademark gives it's easier to enforce against an infringer. So if we get clients where they come to us and say an infringer is copying or they've copied our brand, if they have a registered trademark, it's much easier for us to enforce. Because if you didn't have that trademark, what we would ultimately be relying on is your goodwill. And so we'd have to, as part of any case, show that you have sufficient goodwill, that there would be a misrepresentation on the part of the public, which is harder to prove than a trademark infringement claim. So that's one. The second one is it's a good deterrent. So if you've got a registration, you can put, as we said before, the R next to your brand. So it's a good deterrent. But also, just to go back to the clearance searches that we spoke about before, when businesses do these searches, they'll find your brand in the search, and so that again, that is another good deterrent. And from a copyright point of view, copyright is there not essentially to protect it as a brand. It's there, so I wouldn't think about copyright in relation to names at all.
It's just trademark.
Yeah. So and then if it was, copyright would subsist in the logo, but as I say, there is a real advantage to having registered trademark protection. And actually, if you've had them for a number of years, obviously they're a really valuable asset, because your rights then will obviously date back to the date that you filed them. So that's another reason is if someone was looking to buy your company in however many times, actually it's a valuable asset for the business to own.
Does that help answer your question, Dominic?
It does. Just can I, if you don't mind, as a follow-up, I mean, you sort of say that, so the brand has been around for 20 years. Say it was Coca-Cola. I wish I owned Coca-Cola.
Yeah.
I assume it's a registered trademark, Coca-Cola. If they deregistered it and somebody set up Roca Roller, surely everybody would know immediately that was a copyright infringement, even though it wasn't registered. So
there would have to be, so they'd then rely on passing off. So there'd have to be some kind of misrepresentation that there was. So in terms of passing off, you need it's kind of a higher level. You need to show that the customer is deceived into thinking that there is definitely kind of some sort of association. Whereas in trademarks, you would just have to show that there's a likelihood of confusion. So it goes one step further. It has to be a misrepresentation that either Coca-Cola is responsible for that brand, and actually you wouldn't expect really Coca-Cola to be using that brand. You might not be able to get over the hurdle of misrepresentation, or that there's some kind of association. So there would still be a risk, even though the brand is so big. Coca-Cola would still benefit from having the registered trademarks, definitely.
Okay.
Brilliant. Thank you. Thanks for the question, Dominic. It was great. Rob, Mr. Brooks has asked the question, how do they decide if a word is in generic use and therefore cannot be registered or not?
So when you file for the trademark, there are a number of examiners at the relevant office. So, for example, the UK Intellectual Property Office, and they will examine it. And there's a reason for that kind of rule, is that what they don't want to happen is they don't want to give businesses certain rights to certain names, for example, that actually are generic and that other people should be able to use, that are, for example, descriptive of the service that they're providing. So that's the reasoning for it. And then actually it's reliant on what the examiner determines at that time as being kind of generic, or the most common one is that it's descriptive of the thing that people are doing, because actually sometimes people like their brands to include something that indicates what they're doing, but often that causes a lot of kind of trademark issues. And if it is rejected initially, there are a couple of options. We can argue with the examiner and try and persuade them that they're wrong. The second option, which we have done, and we've done successfully, is that you show that even though we say, okay, we acknowledge that it's not inherently distinctive, so it's not capable of distinguishing that entity's goods or services from another entity's goods or services, but actually we have used it, the business has used it for so long, and nationally people associate that brand with us, and we put a load of evidence in and witness statements to show that, and sometimes you can get the mark through because it's acquired distinctiveness.
So Ellen's just put a comment in saying it's worth looking at how Brewdog dealt with Aldi when they produced an IPA that was clearly a copy. Very clever. Yes. I mean, I must admit on that, when I've been over in Spain and we've been into some of the supermarkets out there, and I saw one that first glance almost said Carling, but it didn't. It said something else. But the wording, the design was the same, the font was the same, colours were the same, everything. So sorry, I interrupted your flow. Then you were going to say something about the Brewdog.
No. It's an interesting way that they resolve it, because you see a lot of things in the press where people are either strictly enforcing their rights, but sometimes there's a PR angle that can be beneficial to try and I suppose resolve it in a bit more of an imaginative way. So it was an interesting one, but it's all, I suppose that's the passing off element, and a lot of say discussions like this that I have, a lot of people say, well, I don't understand how especially the budget supermarkets, are
Yeah.
able to sell so many products that obviously look like, and they call them copycat products, which is what
Yeah.
a lot of people refer to them as. And it's the point that I made before about a lot of people, businesses will be relying on passing off. And actually, if you go into a budget supermarket and you see a product, it'll bring the brand leader to mind, because that's what it's intended to do. But actually, you're in a budget supermarket, and by the time you've picked up that product, you've gone to the till, you've paid for it, you know that you're not buying the brand leader brand, so there's no misrepresentation there. And so that's the main reason that they're able to kind of get away with it, for want of a better phrase, because of the fact, well, there's no misrepresentation, and they're not kind of riding on the back of the reputation to the extent that we're then thinking, oh, well, it must be the brand leader's product, or there must be some sort of association. We know that there's not. And that's, I suppose, where I come back to the registered design protection for packaging and things, because the test for infringement for a registered design is whether it creates the same overall impression, which is a nice vague term that we like to argue about, what the overall impression is. But you can see there that some of the copycat brands, if they had some sort of registered designs in place, you can see that they might have a stronger argument, because I suppose the whole idea of a copycat product is that the overall impression kind of hints at the brand leader.
Different target audience as well, isn't it? I don't think Aldi are ever marketing to a luxury kind of clientele like a Jo Malone candle would do, or a Charlotte Tilbury, piece of makeup. It's more the fact that Aldi are very clearly, they have their own target audience, and that's what they like to stick to. So again, it makes that argument much easier to have, doesn't it, Gemma?
Yeah. And I guess they kind of thought this through as well. I've got a question in from the lovely fresh-faced Dean Towers. For those of you who don't know Dean Towers, he shaved his beard off the other day and now looks very, very useful.
He's now joining a boy band, aren't you?
He is now, yeah, he is. He's not years off him.
Go on, get it over with.
Your question is a great one, Dean.
So, BCS Electrics, the company that I own, has been going for 70 plus years. Yeah. And about 5 years ago, we did a brand refresh. The people that we use for brand refresh website and everything, we asked the usual questions: do we own IP? Have you got out to do with it? Do you own out to do with it? And they were like, no, it's all yours. And they did say, look about trademarking it. So we're like, right, okay. Anyway, we never did do. And then we're in the process now of having another 2 companies under that BCS brand. Now, the 3 companies all do different things.
Yeah.
And the only difference to the brand is we have, it says BCS and there's a line, and then it'll say electrics and then a line. The only difference making to the brand is one will say electrics, one will say fire, and the other will say security. So my question on that is it, you may have already covered it, are they independent? Do they all come under the BCS banner? And there's loads of BCS electrics and everybody else out there, but just not branded up like we are. Obviously, I'm thinking now, I want to protect them anyway. How do I go about doing that?
So, I suppose with trademarks, you've kind of got the freedom to protect whatever your brand is. So, and it depends, I suppose, how much money you want to spend on it and how many you want to file. So often, if there's an umbrella brand and a client wants to keep costs down, then we might just file the umbrella brand. But then if there's different branches to that and cover all the services that each of them, the different businesses then use the mark for. There are benefits, though, of having a more thorough protection and protecting them in each way that each of the businesses will use them. So having the extra BCS electrics and then fire. And one of the reasons for that is, say, for example, if a third party then after you kind of copied the brand, I suppose if they did it, but I mean, it's not the best example because it's only kind of the 3 letters, but actually you can see that if they didn't use BCS exactly, or they didn't use it in the stylization exactly that you protected it in, but they also had the element of electrics or fire, you can see that then would make it closer to what you had protected than maybe if you just had BCS and they were using something slightly different to BCS. So it's a roundabout way of saying it depends how much money essentially you want to spend on it and how many trademarks you're willing to file. And I suppose what is kind of another consideration is if you've got different businesses using the brand, you then, I suppose, either you need to decide who owns the brand ultimately, whether you did want BCS Electrics to own BCS Electrics, BCS Fire to own BCS Fire, or actually you've got one company that owns the brand and then kind of permits the other businesses to own it, and then you need then the goodwill to be in the same place. Really, that's the best place, is to have the goodwill in the business that then owns the trademark. But that's kind of a restructuring point, and there are quite a few ramifications, say tax implications and things like that need considering, but it's just things that kind of to think about, I suppose.
Well, the thing for us is the setup as it comes under the BCS brand, but they're all set up as different companies, so they're not. We have a holdings company that owns electrics.
Yeah, okay.
That was just from some advice from a while ago.
Yeah.
So what we're thinking about doing, because we've kept them independent, the reason that we've done that is obviously for one, to protect us brand, and then in 10 years' time, somebody might approach me and want to buy electrics, so we sell electric stuff, and then we keep the other two, doing it that way.
Yeah.
But we're looking at it's obviously it's for my get out plan, really, at the end of the day, for all this protection stuff. But if we look at selling them off independently, I just sort of don't understand where if I own the brand.
Yeah, I know what you mean. I think if I'm honest, I think there are a few options for you, and it might be something we could follow up on offline on that, because I think it's going to have bigger implications than just, do I want a trademark? And actually it probably needs a bit more thought, because it probably involves kind of structuring the business and things like that. So I'm happy to kind of follow up with you on that and have a bit of further thought on it, because it'll just have more implications purely than owning the right brand, essentially, and getting the right trademark.
Yeah, we're going to do to work with you guys anyway, so it'll follow on nicely.
I think it's a great question though, Dean, and the fact that it just goes to show how complicated some of this stuff can be, and that what you don't know, which is what we're trying to get over on this, is actually there's a lot of things to go at. I'll just do one simple question from Rob again, and then we'll kind of just go into sort of wrapping some of this stuff up. And he's put down, if a written article blog, if writing an article blog and want to use content from a third-party website and they have generic copyright disclaimer, unlike to be registered on their website, can you copy text verbatim and use an image, or if you credit the site?
So I think this is a kind of common misconception that if it's free and available on the internet, and when I say available, I mean you can just access it, it's likely that someone will own copyright in that. So if you just take text or take an image, you're likely to be infringing somebody's copyright. There are obviously sites that allow you to use those materials, and a lot of them do say you need to kind of maybe credit the author, and it also in those you need to just make sure you're following the permissions and the terms of those permissions properly. But just because it's on the internet and you can physically take it doesn't mean that it is free to use.
Okay, cool. Hopefully that answers your question, Rob. I'll just do one more question. Imran's just popped in. So Imran from a sensor said, does a single black mark cover all colours? Now I'm assuming that's someone's done something a bit naughty.
Not anymore. So we used to advise years ago that a black trademark, so black and white, used to protect that logo in all colours. So if you had the black and white trademark registered and somebody was using that logo in red, that technically would be use of an identical trademark. So you have a stronger trademark infringement claim. However, now it doesn't. So if you have a brand where you use a number of different colours, it takes a bit more thought now as to strategy as to which you want to protect and how we do it. And again, it comes back to what I said before, I suppose, how much money you kind of want to spend on it. So it used to, but it doesn't anymore. So there is various options, and in an ideal world, you'd file probably a trademark for every colour that you use it in, but some brands use so many different colours that maybe you pick your key colour, and maybe a black and white one as an extra one or something, and there's an option of series marks. So I know I've answered your question in a bit more of a complicated way, but not anymore. And there are also kind of use issues. So when you have a trademark, once it's been registered for 5 years, it's vulnerable to a non-use attack. And so really you want the trademark that you are protecting to be in the form that you are going to use it, to try and avoid any arguments from kind of competitors maybe, as to trying to attack those marks in the future.
Brilliant. And I thought black mark would mean you'd done something naughty.
I see.
I thought you'd done something naughty and you want to see how long you'd last, but that's fine. Just kind of looking to give away just a few kind of top tips. What, just to kind of wrap up, I'm just conscious a little bit on time, is what the sort of top tips that we could give people to say, look, check this thing out, top things that you could think that actually, you need to just think about these things in your business.
Yeah, I think it just to kind of boil it down to 5, I suppose, key headlines. So we've already touched on some of them, but the first one is a bit negative, but it's risk. Have a look at kind of the landscape that's already out there, because intellectual property rights, so such as a registered trademark, it doesn't protect you from being sued. It just gives you the right to enforce your rights against people. So it's we say it's kind of a sword instead of a shield. So it doesn't protect you. So even once you've got your registered trademark, you could still be sued effectively for using it. So the first one is risk. Second point to think about is kind of protection. So do you need to apply for a registration? Would that be the best way of protecting, say, the brand or your innovative product? And if not, what other ways can you think of protecting it? So such as contracts to protect confidential information. So how can you make sure that whatever's valuable in your business is protected? The third one, which we've not come on to, but it's really important, is ownership. And a lot of people think that, well, I've paid this design company to do this for me, so I must own it. You need really to be making sure you get the right kind of document in place, and it can be quite a short document to assign the legal title to what they've created to you. So ownership's quite a key thing, and make sure that everything that you get created bespokely for you, you actually get the title to it. The fourth thing is kind of third-party IP, which we've already kind of spoken about, using third-party IP, and all businesses will use it. Have you got the right permissions in place? And also, though, if somebody's designing something for you, have you got the right assurances from them that they've not copied it from somebody else, and actually that you're not going to end up in an infringement action because of the fact you're using a design that's been created for you, or a product that's been manufactured and designed for you. And the final one is kind of having a plan, like you said, Mike, and IP management, really identifying your IP and actually having a bit of a plan of if someone comes along, enforcing your IP and making sure that, I suppose, you're keeping the value of it in the business.
Right. Yeah. No, I think those are really valuable takeaways for people to kind of think about, going forward. And it is thinking about how you put it all together in the plan. That's the key thing. And I just wanted to share with you my screen, which is one of the things that we've developed over a while. Is just it's a way to help you plan things through. So at ThinkSMART, we developed a marketing plan that actually help convert the sales. So we know that, with a lot of things that are going on at the moment, that actually the biggest thing is, and what we asked our audience was actually people wanting a plan to be able to help put all this together. So we pulled together a Trello board, which actually allows you to build your own marketing plan, but actually then starting to think about all the things that we've talked about with Jemma, how you can filter all these things in and actually build it as part of the whole process. So you're not getting caught out, whether it's working with us or whoever it might be, is having something in place. So we've taken all our expertise and built a series of download documents and Zoom calls and video content, plus along with face-to-face Zoom calls that we'll pull together that actually then help to pull your plan together, which we know whereas a lot of places are kind of struggling with. And it's something we're offering out at a fraction of what we do at the moment. But again, the thing to reinforce for us is actually that it's so key to have a plan in place, that, you know, whatever it's doing, whether it's your marketing strategy, whatever, is to have those kind of places, that plan in place. I know we got Rob on the call who's actually gone through and done the plan with us, and actually we get to review the plan and help you going forward. So it's just ways of, just another way to tie everything together, and we're all about where we can, you know, offering the value so that when you come to implement your marketing, you can really have a structure to it. It's where a lot of people kind of fall over. So has anyone got any kind of final questions that they want to throw at Jemma before we end? But hopefully you guys have taken quite a lot of value from that, and there's been some really valuable content. Jemma, if anyone wants to contact with you, how can they do that? Is that best through LinkedIn? Is it dropping you an email?
Yeah, I'm on LinkedIn, so if you want to ping me a quick message on there, then I'm happy to arrange a call, Dean, with you to follow up on those points that you said. But anybody, if they've got any questions they want to run past me, then yeah, always more than happy to have an initial chat. Yeah, I think it's just about making sure you're ticking the boxes, isn't it? And then making sure you have got stuff covered so there's no nasty surprises when it comes out of it. You know, that's the whole point of it. So on that note, if no one's got any other questions, thank you ever so much for joining us. I hope you guys have taken some great value out of it. I know I've learned stuff, and it keeps on, my mind just keeps on filling up with stuff. There's more and more you dig into it, there's more and more to know. So it's about asking the experts and helping along. Thanks to Clarion, thanks Caroline for helping organise this as well. Thanks Jemma so much for your time. No problem. Thanks everyone for joining us. Hopefully next time I see you, Dean, you might have your beer back. You're going to say anything useful. I hope that's answered your questions as well, Dominic.
Yes.
I know you have more, and you were quite short actually today. You were quite to the point.
Don't be like that.
I was expecting you to go on for ages. Thanks for joining us, Caroline. I didn't see you on there, but thanks for joining us. Yeah, any questions, ping Jemma a note. Thanks for joining us. We'll be back, I believe, in November with some more webinars coming up. So thanks everyone. Have a great rest of your week, and speak to you all soon.
Thank
Cheers,
you.
Guys. Thank
Bye,
you.
everyone.
Bye. Bye.
Hello, this is Rob from Death and Disease. I want to give a quick shout out to the guys at ThinkSMART Marketing. We've just finished their marketing course and it was really excellent. Here at Death and Disease we do all sorts of marketing, newsletters, videos of people sitting in reservoirs, all sorts of things. But we wanted to make sure that our plan was completely coherent. And we did their marketing plan. It wasn't expensive at all, and it really gave us lots of new ideas that we'd never thought of, and it brought our plan completely together. So I strongly recommend it. So thanks very much, guys, and we look forward to working with you in the future. Thanks a lot. Bye bye.